Why Utah courts should explain how they hear children in child custody cases. There's an assumption in Utah child custody cases that almost no one questions, that the only acceptable way for courts to learn what children know, experience, or want is through a guardian ad litem, known as a GAL for those who work for the government, or a PGAL with P meaning private guardian ad litem, or through a custody evaluator. At first blush, it feels responsible, it feels protective. What's not to like about appointing an advocate for the child in the form of a GAL or PGAL? Why wouldn't you want a professional to evaluate and make recommendations pertaining to child custody, right? But concept and aspiration are not the same as reality and actual practice, and you'll find those are quite divergent as well. The GAL and custody evaluator proponents are never expected to prove their ideas actually work. This isn't an attack on guardians ad litem or custody evaluators, although current GAL and custody evaluator practices in Utah scandalously leave much to be desired, but that's a subject for other videos. And this is not an argument that children who are the subject of child custody and parent-time disputes should routinely testify in every case in court. It's a question, a clear and narrow question. Why do courts categorically reject on-the-record inquiry with the children while accepting unsworn, unrecorded summaries from GALs and custody evaluators as a substitute for evidence? In every other kind of civil case, courts insist on evidentiary discipline. Witnesses with personal knowledge testify. Statements are preserved for the record. The objective beats the subjective, and findings rest on a record that can be reviewed. But in child custody cases in Utah, children, often the people closest to the facts, bearing directly on custody and parent-time determinations, are treated not as valuable percipient witnesses, but as categorically incapable of testifying and in need of protection from the very act of giving evidence. Instead, courts rely on second-hand, unverifiable summaries about what a child allegedly wants or feels, filtered through an intermediary, without any record of how the information was elicited, if at all, or what was actually said, if any. The court is not weighing testimony, it's accepting a professional's narrative about what testimony might have been. Utah law requires courts to assess what children know, understand, and desire, and that requires evidence, not supposition or bald conclusions. Without a record, courts can't evaluate reliability. Appellate review becomes illusory. Context and nuance are lost. Good intentions don't solve that problem or justify avoiding it. Merely appointing a professional does not convert an interview into evidence. Without a preserved reviewable record of both what occurred during the interview and the circumstances under which it occurred, sufficient to evaluate interviewer neutrality, competence, and the absence of coercion or undue influence, the court has no evidentiary basis on which to make findings. This is not an argument for putting children on the witness stand and subjecting them to adversarial grilling. Courts already possess well-established tools to regulate the manner, scope, and conditions of testimony to ensure it is developmentally appropriate, reliable, and fair. Those tools include alternatives to open courtroom examinations, such as in-camera judicial interviews and narrowly scoped depositions, designed to elicit reliable testimony while minimizing unnecessary formality, pressure, or exposure. What's missing with GALs and custody evaluators, at least with current practice in Utah, is transparency. Structured, recorded inquiry is a fundamental tool of sound civil litigation. It's not radical, it's indispensable, because it creates a record the court can evaluate, the parties can test, and a reviewing court can meaningfully review. The question isn't whether current practices feel safe or familiar, it's whether they are justified as a matter of evidence. Until courts are willing to legally justify, on the record, the substitution of unrecorded conclusory summaries for record-based inquiry, the legitimacy of those custody determinations remains an open and unresolved question.